So I think we are ready to engage in some panel discussions and stop hearing me talk. So how can defense provide quality representation to individual clients within an evidence-based practices framework? I'd like to ask if we could, I think, Richard, we're going to start with you. Oh, sorry, I think I'm wrong. Apologies here. I would like to actually ask Chris Flood from New Orleans because, and for those of you who are listening, one of the things that we know about New Orleans is that it's a system in transition, a system that is a lot going on at the policy level but also at the individual representation level. And Chris has been both a federal defender and is now a top leader in the reform efforts that are going on, not only in New Orleans, but across the South, and also training young defenders to be advocates for their clients. So Chris, may I just ask you your thoughts on this, how we can improve the quality of representation to our individual clients, ensuring that their rights are protected within this evidence-based practices framework?
Great. And thank you, Kate, for the opportunity to speak on this. You know, reflecting back on part of your introduction, you know, we have, specifically in New Orleans, we have one of the highest incarceration rates in the country, thereby making it one of the highest incarceration rates in the known world. And you know, we have it that rate of incarceration because I would suggest that systemically we've over-relied on incarceration, particularly in pretrial. So I'm going to direct my thoughts here mostly to evidence-based practices at the pretrial level. And I think what that really translates into, and as every defense attorney who you know, is paying attention you know, cares about, it means that there's more information about our clients that's being shared among stakeholders. And that is both an opportunity and cause for concern. But I would suggest that more information at the pretrial level, the bond setting, about our clients' characteristics is a good thing, and a good thing for many, many of our clients. And I would contrast that with our use and over-reliance on cash bond, which really doesn't take much into account. It looks at the nature of the offense and our client's criminal history, and that's about it. So, you know, when you have a very limited source of information like that, then things tend to go against our client's best interests. On the other hand, there are risks involved. You know, when we talk about an increased amount of information in the hands of the prosecutor or of pretrial services or courts, you know, the source of that information is our clients, and that, of course, raises some Fifth Amendment concerns. And the reason I want to highlight that now is because when we think about like how we as defense attorneys can function in this system in a way that I wouldn't say not just doesn't harm our clients, but really works to our clients' best advantage, we do require, I think, some collaboration with other stakeholders. In particular, we're talking about the amount of time. And so the amount of time we have with our clients. And I think that's a real issue that needs to be on the table from the beginning. Because if our clients are going to be engaging in a pretrial interview with a state agent, asking for, you know, doing a risk needs assessment, there could be questions that it would not be in our client's best interest to answer. And as counsel, you know, we have to develop a sound relationship with our clients to be able to give sound advice about what kind of answers to provide and whether to engage in the interview at all. So, you know, that puts some pressure on our fellow stakeholders, and I think that means that we have to be at the table early on. And I think that the other thing there is that being at the table, we need to understand and fully understand the limits of these instruments, because there will be clients where there will be risk needs assessments that our clients will not see as in their best interest, and we'll need to know how to advocate around these things. But the only way we can do these we can succeed on all these levels is to really have a strong voice in the use of these tools.
And Chris, if I could just ask one more question of you, and that is, what happens when you have huge caseloads? Is it possible to really advise your client well when you're moving thousands of people through and you have limited time?
I would say it's an incredible challenge. And so what you point to, Kate, is how interrelated all of the issues with systemic development of evidence-based practices pull out. We can't just say, okay, well, we'll drop evidence-based practices on an otherwise broken system and hope that it's going to succeed. It really is part of a overall reform, and part of that for us as defense forces to get our caseloads down to something that's reasonable.
Great. Richard Goman, would you provide your thoughts on this issue?
Yeah, I think more generally, when we talk about evidence-based practices, we're talking about the criminal justice system as a whole. And I don't think that the superimposing evidence-based practices within the criminal justice system really changes the role of the defense attorney at all. I think that in many ways it creates additional tools for the criminal defense attorney to use. Evidence-based practice instruments, whether they're used early in the process, pre-trial, or at diversion, or later in the process, at the probation or sentencing determination, the tools that are being used are ones that the defense attorney needs to become intimately familiar with. They need to understand the tools, and they need to understand how to use them on behalf of their client, so that in many ways this kind of practice can be beneficial because often it makes explicit what was implicit before. So probation officers, judges, prosecutors maybe, other stakeholders were making judgments and making arguments based on a lot of assumptions and implicit understandings of your client and his or her situation. One of the advantages of this kind of tool is it creates explicit data that all of the stakeholders can see and argue about. They can argue both the validity of the data that's being relied on and the meaning of it. But I think the defense attorney, who is often in the position of knowing the least amount of information, can actually have a significant benefit if they are given, in essence, the same sheet of music from which everyone else is singing from. So I think both at the pretrial and post-trial stages, evidence-based practices can be a real support for quality defense work. But again, defense attorney needs to have the understanding of the instruments, and so that's why, as you were saying earlier, folks have to get involved early on, learn what these instruments about, learn their limitations and when they can be appropriately used, ensure that the people utilizing the instruments are properly trained and are utilizing them properly, and then making sure that the proper inferences are being drawn from them, so that they're being used in a proper manner. And of course, if the end result is not supportive to your client, to work to undermine them. In certain situations, that's going to be the defense attorney's role. And I think you're in a much better position to be able to undermine them in an appropriate case if you have a good understanding of the instruments and how they're being used.
Maybe we can say instead of undermining, we'll challenge the application of them. You're not saying undermining the entire use of them.
No, I'm talking about within the individual case, right. With the client's case. Yes, you have to challenge or undermine the result if that result is not in your client's best interest or your client's interest at the time.
Great. So let's turn to this question. Thank you, Richard. Tim Young, I'd like to ask you about your thoughts and experiences during the various decision-making points in the process. How can evidence-based practices influence bail setting, plea bargaining, and revocation proceedings? Can you give us your thoughts on that, Tim?
Thank you. I think, generally speaking, without addressing each one specifically right away, in Ohio what we've seen is just a huge over-incarceration of low-level nonviolent offenders, and which has led to this incredible churning process in and out of our prisons. We're seeing literally 75% of the women sentenced to prison are serving 6-month sentences or less. An entire population is being turned over each year. And similar numbers with the male population. We end up with 50,000 people in prison in this state. A sister state that's almost identical in all socioeconomic standards is Michigan, and they have 20,000 fewer. So we're wasting huge resources. And what evidence-based practices have done for us at each of those stages, bail setting, plea bargaining, revocation, has started to address the public safety and how that over-incarceration is negatively impacting public safety. And so the evidence-based practices are giving defense lawyers tools to argue and present with real certainty to the judge and others making recommendations to the judge that incarcerating this person at a pretrial stage doesn't make sense. Putting a low-level offender in prison means they're going to lose their job. We may well end up with children then being sent into children's services, foster care, and all of those huge systemic costs that come with those decisions. The person is now unemployed. They're no longer paying taxes. We have all of those other costs. With evidence-based practices, we can avoid putting those people into those systems. We can make better decisions about those people who really are a danger. Because what we have found here in Ohio is a lot of those people that are being cycled into our prison, the low-level offenders, low-risk offenders, we're actually increasing recidivism rates. When they get out, they're far more likely to offend than if we had put them through probation and community-based treatment that was much more focused on the risk domains particular to that person. And I think that's one of those things you start to see the person as much more of a whole person rather than the crime committed. You understand that it's an educational deficiency or a peer association problem or a mental health problem, and instead of trying to just put a huge Band-Aid over that, we can much more surgically address the treatment that we're providing. In terms of the plea bargaining approach, it gives you much more argument with what community-based treatment is appropriate for this person and what programs are important rather than just sending them to prison. That we will get a much better public safety outcome if we address that peer association problem or the educational deficiency rather than just lock them up. And especially in a state like mine where we're churning so heavily, they're getting no treatment whatsoever in the prison system. And then it also finally addresses what I think Kate mentioned earlier, that huge population of revocations that are much better treated with better parole standards and increasing the control that you have over the person while keeping them in the community rather than simply revoking on technical violations or on the very first bad drug test. Instead, putting them into treatment programs. But I think it's also really important that we avoid putting them in unrealistic treatment programs that haven't also gone through evidence-based studies so that we understand that they're valid programs, because one of the worst things we can do is revoke somebody based upon failure of a program when the program itself is a failure. So evidence-based practices have been a really valuable tool in Ohio to start addressing the public safety question and how inappropriate prison can be to address that, and in fact can increase that public safety problem. And at the front end, at the bail setting stage, can really increase the taxpayer burden of the whole system without any real benefit. So those are things that I think really can influence outcomes for the clients that can become very positive rather than just a revolving door where you know you're going to see this person again a year from now on another short-term prison cycle.
Thank you, Tim. And what I find interesting is that as we've worked on this project and others, that evidence-based practices in a way make us much more sophisticated And we all know that mental illness is a huge problem for many of our clients and in prisons and caring for the mentally ill in prison. And other issues, like you said, educational efficiency, peer associations, et cetera. But what I really I make the analogy to is that as we become more sophisticated, we are akin to what they used to say about the use of psychotropic drugs. When people were depressed, they sort of gave them the big medicine. And now they've become so sophisticated in parsing out what type of depression and what type of mental illness the person is suffering from. It's no longer opening a pistachio nut with a hammer. It's peeling them apart and understanding what's really going on inside. So that was the analogy about our sophistication, and we have to become even more sophisticated as we learn about the problems that lead a person into the justice system in the first place. So Chris, would you respond to either Tim's comments or also how we can use these practices in a way that assists with bail setting, even plea bargaining, which we know 90% plus of the cases end up in plea bargains, or these enormous number of revocation proceedings?
Yeah, absolutely. I think really part of what I've taken away from what Tim was talking about is that basically any time in these negotiations, be it a bail setting, a plea, or revocation, anytime you're changing the discussion to incorporate the systemic costs that come with incarceration, you're headed in the right direction with regards to your client's interests. Which is somewhat paradoxical, because I think the other benefit is if we're dealing with actual concrete information and evidence that's from a source that's trusted by all stakeholders, then we're actually, I think, able to take a big step towards our clients being understood as people in process of whatever problems brought them before the criminal justice system in the first place. And I do think that that is an improvement. One thing we know about incarceration is it doesn't solve much, in particular pretrial. I keep coming back to it because it's such a problem for us in New Orleans. But you know, if we're using the hammer on the pistachio nut, I'm not even going to try and extend that analogy, Kate. It's too but if we're using incarceration in every instance, which is basically what cash bond is about, then we are both, we're causing more harm than good across the board. If we're sort of adding harm to harm that's already there. And if we are asking the other stakeholders, for instance, in a plea bargain, we're asking the prosecutor to really understand the specifics of our client's life situation. That's good advocacy at any level, but if we're asking them to sort of participate there, I think that is progress system-wide.
Great. I agree, and I know that analogy sounds a little odd, perhaps for those of you that don't like pistachio nuts, but often they're open gently and you don't need a hammer. And what the analogy is that we often throw people in who are low-level offenders and they might come out worse, or often do, or we're not, the underlying illness, like a mental health issue, can be exacerbated when someone is in an incarceration setting where they're not receiving the appropriate care. So I'm going to ask, I think we have our polls at this moment to give everybody a chance to participate, and then we're going to go on to a question number 3 after this polling. So are you using evidence-based practices in your work with criminal justice clients? If you would take a moment to vote, that would be great. Vote early and often, and we'll see what the poll results are for that. Okay, so we have a large number of people. That's great. 75% of those of you on this call, on this webinar, do use evidence-based practices in your criminal justice work or representation. 18% don't, and 7% respond that not yet. And that's wonderful, because I think we'll have a rich conversation after we have our third question. Now let's just do our next poll question, which was earlier in the webinar when it wasn't working. I think it should pop up very soon. Could you just let us know, so we have a sense of who is on the phone, if you work in the city, county, state, or a federal jurisdiction? feel like we should have a clock going, tick-tock, tick-tock. We'll get a sense of who's on the phone. Here we are. 5% from the city and 39% from counties. And 45% of those of us on this call are state and 11% federal. A nice array. Thank you very much for answering that poll result. And now we're going to move into our third question, and then we'll open it up for questions for the panelists. So I'd like to focus on this issue that we raised earlier, is that we really have a role. I always say a good defense attorney has to be an advocate at every moment in the process. You're an advocate for your client, but one of the areas that we're really trying to become more conscious and more effective is at the policymaking tables. And this we mean local, state, county, federal. We need to have a place at the table to ensure adherence to constitutional protections, but other protections. So I'm wondering if the panelists could think about that question, and we could start. We will start with Richard. Are you there? Richard Billman. You have been active as both an individual defense attorney at the state level, particularly in Virginia, and now DC Law Students in Court, but also you've been active at both the state, local, and the federal level and in Congress. Could you talk a little more about that?
Well, actually, yes, I can. And like any good policymaker, I'm going to first answer the question that I want to answer, and then I'll move to the one that you did.
I'm getting a good moderator. I'll push you back to the question.
Yeah, I just wanted to note for a second that we're all talking basically about the evidence-based practices pre-trial and post-trial, and I just thought we should be explicit that we all kind of recognize that during the adjudication, the trial stage, when the whole guilt-innocence piece of representation, we're just kind of skipping over that. And when we talk about sentencing, we're kind of assuming, certain outcomes. But we've explicitly, talked about the fact that evidence-based practices at this point probably doesn't have a role to play for a defense attorney in the adjudication stage. And I just wanted to make that explicit because, it's sort of been implicit in all of our answers. Now, in terms of a policymaker, it's vitally important for defense counsel to be present at a policymaking table, and oftentimes defense counsel is not there. A lot of the problems are systemic in the way defense counsel systems are organized, but it's really important that no matter how a state or county or city defense bar is organized, that they find some way to get a representative at whatever policymaking body is considering evidence-based practices for their criminal justice system, whether it's on a local level or whether it's on a state level. It's important because defense counsel are always going to bring their deeper understanding of our clients to the table. I think they'll also bring a healthy skepticism to the table, which is an important component when examining any kind of new innovation. And specifically, defense counsel should be asking a lot of questions about the use of these instruments. How are the instruments? How are we going to be ensured that the instruments have been properly validated? How are we going to make sure that the assessors have been properly trained? How are we going to be sure that the assessment is used appropriately with the appropriate clients and at the appropriate place and time? How are we going to avoid the net widening that we talked about earlier? How are we going to ensure that constitutional protections are built into the evidence-based practices so that a client can be in a position to talk to a probation officer or social worker or whoever the assessor is early in the process without fear that what they say is going to be used against them in any way other than through the instrument itself. So there are a lot of questions that public defenders can bring, and the expertise of coming from their clients, have a deeper understanding of their clients than really anyone else at the table. Also, the fact that evidence-based practices, as I think both Chris and Tim have alluded to earlier, they require time, they require resources. And for public defender systems that are suffering under high caseloads and low resources, what that means is for attorneys that they don't have the time to properly represent their clients. And a system's interest in evidence-based practices can be used as a lever to say, we are willing, our public defense system is willing and able and wanting to work within this evidence-based practice, but we need the resources to do it right, or else we lose the fidelity that Kate talked about earlier.
If I could
Thank
just
you,
pipe in
Richard.
there, can I just throw a quick comment?
Absolutely.
To that, which is that if any conservative defense attorney unable to properly advise their client about whether to engage in a bail interview is likely to advise them not to engage in a bail interview, which will frustrate the purposes of having the evidence-based practices at the front end in the first place. So with regards to, we're often last at the table of the defense, but in this instance, we really are a critical component, and we really should be raising our voice as such, I suppose.
And I just want to add, Chris, I think it's not just getting to the table, because I think all of us on this call who have been defense lawyers and who've been invited to a policymaking table where you're sort of the lone defense lawyer, and then you're really not heard, or they say, oh, well, we had defenders at the table, and then it was overwhelmingly prosecutors or police, and there's not a balanced, or I should say, there's a rubber stamping is what I raised before, and that can be incredibly frustrating. And then sometimes I've heard defense lawyers who say, I just don't go anymore because they only invite one of us, and then they say, oh, the defense was at the table. So important for those of you who are not in the defense world to ensure that there's an authentic voice and that the voice is actually validated at the table. And so, Tim, on that note, I know that you are often invited to the table. How do you ensure that when you are at that policymaking table that you ensure adherence to our constitutional protections?
Well, I guess I see that as my purpose, being at the table, is to be that voice, to constantly remind people, as good as some of these evidence-based tools are, there is a right to remain silent, and there are times we're going to advise our clients to do that. And there are reasons, legitimate reasons, alluding to what Richard said. If we're certain this case is going to trial, I don't want my client talking to anybody about anything. There are reasons for that, and legitimate reasons, and constitutionally protected reasons. And so one of the main roles at being at the table is simply making sure everybody continues to understand that this is just one more tool to assist everyone in the system, and there are times that we don't want to use this tool. And there are legitimate reasons why we might advise a client not to participate at a pretrial stage, or even potentially at a sentencing adjudication stage, in terms of what they may say just simply is not going to be useful, or the way they communicate is not going to be heard in a way that's useful. But I think the second piece that being at the table for the defense bar is, if you have a legitimate voice, you start to get buy-in of the defense bar in the use of the tool. If the tool is truly legitimate, if it's been validated, and not just validated in its use on clients, but you have to validate the tool from also those assessing the client. If they're not constantly being validated, you can get huge skews in personal predilections favoring outcome towards one thing or another in terms of who's assessing your client. And then also in terms of not just administering the instrument, but the use for its determination in the outcome for your client. And those are very, very important, that evidence-based practice sometimes can be so focused on just what we're testing for that risk test for the client, that you forget that it's only valid if you're testing the whole system. If you're testing the tool itself, constantly validating it, constantly renewing validation of the people assessing. And so that's a second piece to make sure that we're protecting our clients' rights as they go through this process. And this doesn't just become a check the box and be done with this person, but that this is a tool that's being legitimately and validly used. And finally, you got to come back to the cost issue. If you're going to be doing evidence-based practices, Chris said it at the beginning, more time with the client. We all need more time with the client, but if a court system wants to start a pretrial services program and expand it so that they've got more pretrial services officers, it's very difficult for a defense lawyer with 15 arraignments that morning to have any meaningful conversation and be able to advise the client on what this tool is, why these people want to ask him these questions, and what those questions, the answers to those questions might be. And as a result, your default is always going to be, don't talk to them until you and I have had more of a chance to talk. So if you're going to expand funding, expand these evidence-based practices in other areas and give more resources to other areas, you've always got to remember that the defense has to be included. And being at the table provides the opportunity to voice that and continue to voice that. Finally, you've got to have the buy-in. If the defense bar doesn't believe in the tool, if they haven't had a legitimate voice in the development of this tool, in understanding how it was developed, why it is valid, they're going to constantly advise their clients to not participate. And if they're not participating, doesn't matter how good the tool is, it's just sitting on the shelf. And so ultimately, it's incredibly important that we have that legitimate voice early to maintain those constitutional protections, maintain that balance of resources, and to focus on the broader efficacy of using evidence-based tools across all of those who touch them.
Thank you, Tim. And I just want to add a note to that is that as I was listening to you, I was recalling those studies that have come out where a client, or particularly juveniles, will go through an entire process and be sentenced, and they'll interview social workers or sociologists will interview them afterwards and say, do you know what happened? Tell me what your sentence was. And the comprehension simply wasn't there. They didn't understand what happened. They didn't understand the process. It wasn't explained to them. And they were oftentimes, it was either because of perhaps education level or the questions were just confusing. And so applying that same thing to these tools, we need to make sure our clients really understand what's going on and the questions that are being asked. And we all know how nervous our clients get when people are interviewing them and questioning them. And so comprehension and accuracy are very important. And then finally, we all know that there's a right to a fair trial and a jury of our peers. And then as both Richard and Chris and also Tim raised, it's very important for those other players in the system to understand that it is our obligation, our ethical attorney-client privilege and obligation to ensure that that client has their rights protected, and that means a trial, and sometimes it means foregoing the tools that are available, and they shouldn't be punished for that. Just like problem-solving courts, if you don't use them, you shouldn't be punished. It should be for problem-solving. And so that's a whole other day of conversation. Now we're